No matter your age, your plan for retirement can start today. From the News Channel 5 Network, this is the Retirement Report.
Good morning. Welcome to the Retirement Report. I'm Hank Parrott, your host. We've got a really good show on for you this morning. This is one of those, again, I've talked about estate planning in the past, and in my book, 7 Steps to Financial Freedom in Retirement, Chapter 7 deals specifically with estate planning. And we've talked about the basics of setting up a good foundational estate plan, that of having a trust, a pour-over will, powers of attorney for both assets as well as for health care, and a living will directive where you let your wishes be known to your loved ones in terminal situations. So all of these 5 documents, the 5 essential documents, in fact, that form the foundation of a good, sound estate plan we've talked about. Today, we're going to go a step further. We're going to get into some new legislation that was just passed this past year. So if your estate planning has been done over a year ago, all right, more than a year ago, then in particular you want to pay attention to this, because these new laws may have an impact, and this may be a time for you to want to get in and review your trust documents, review your estate plan with a good estate planning attorney. And I have a great estate planning attorney with me today. It's my good friend Russ Cook with Russ Cook and Associates. Russ is a board certified estate planning attorney, and he is here today to share with us about this new legislation. And Russ, one of the things that I was taking and looking at, you do seminars and workshops basically for planners where they can come and get continuing education and learn things with regard to estate planning, and this is taken directly from that. So this new legislation was passed July of this past year, and one of the things you stated was a continuation of the state of Tennessee's efforts to make Tennessee a more attractive legal environment, or the most legal, is it? Yes, the most. Okay, yes, we're right up the top here. The most attractive legal environment in the nation for trusts. And that's a pretty strong statement. So tell me a little bit about that.
Well, and thank you for having me on. I appreciate you bringing me on today. But what Tennessee is doing is trying to adapt their legislation to be able to be at the forefront of trust planning. They see a benefit to providing a service or trust code, I guess, that would allow out-of-state money to come in-state, and of course to protect the in-state money that's here. So the Tennessee legislature has been very aggressive in passing legislation to allow for estate planners such as myself to offer these really great trust protections, trust law that comes in and allows for us to estate plan to protect assets from generation to generation to generation.
And this is one of the things we've been working together with clients for over 10 years, and it was before I think when I still had hair.
Yes.
You know, and when yours
there's a bit there, yeah,
just a little,
yeah.
But I remember, you know, I remember one of the things, even going back then and going back, I've been doing estate planning now, you know, with clients for probably 20 plus years, and one of the things that's always been the case is people want to know, how can I protect my assets for my beneficiaries? Okay, you want to keep it, I mean, most people come in, it's about keeping it in the bloodline, right? You've worked hard for your assets, you want to be able to protect those assets for your family, for your children, your grandchildren, and so on. If an in-law becomes an outlaw, you don't want the outlaw taking the money with them, you want to keep it in the bloodline. And asset protection features sometimes coming into play also for where you want to protect, maybe you've got children that, and this happens in many families, of course, so there's usually always one, as they say, where maybe that child's not as responsible, or maybe they've got some other issues going on in their personal lives to where they're just not the ones you want to all of a sudden turn over some money to. It'll probably be gone. They might even harm themselves in ways as far as bad habits or what have you. So it's to protect them against themselves in some instances. So with the new laws, and this is one of the areas, asset protection is a huge issue for, I know, our clients. How does this help strengthen that, maybe?
Well, the great news is with these new laws, what we're doing is allowing for trust assets to stay in trust for a beneficiary's lifetime. So in other words, typical estate plan may have assets go directly to the children, either outright at the surviving spouse's death or when the children reach a certain age. Well, what we've done here, this law says that when you create a trust for a child, you can protect those assets while they're in trust for the child during the child's lifetime. So if the child ends up getting married, divorced, or creditor problems or anything like that, the child doesn't have these assets exposed to those type of creditor claims. And you can even make the child the trustee of their own trust and still protect these assets while they're held in trust. So to paint a picture for you, mom dies, transfers assets to the two kids, instead of giving it to them outright, says let's just keep it in trust for the child's lifetime, make the child the trustee, the child's the beneficiary. That way, during the child's lifetime, the child has access and control of the funds, basically, you know, as if they still own them, but not necessarily in that fashion because it's in a trust. But they do have a lot of latitude in how they spend and invest those assets. And then when the child dies, those assets go according to the child's wishes through their direction in their estate plan. But during the child's lifetime, these assets cannot be attached by the child's creditors. That was an issue we weren't sure was going to play out in Tennessee law because the case law was going all over the place. Well, then they passed this trust legislation last year that said, if you set up the trust right, there's no way the creditors can get at these assets. Same with marital claims. We were concerned that maybe during the child's lifetime, if they get divorced, the ex-spouse can get at these assets, either in a marital dissolution agreement, or maybe if they get behind in alimony payments, there might be a claim against this trust. Well, here again, the law has stepped in and said, no, you can't come after these assets through a child to try to get these trust assets. So it's given us a lot of strength to tell clients, or it's given us a lot of backing to tell clients, this is the way you really need to consider setting up your estate plan, even if you're not really giving them a lot of money, just to protect the little bit that they have.
Well, and it's one of the things before, one of the areas when with doing asset protection and working in that area for many years with our clients, one of the things there, you would have to go to greater lengths to put in language more specific to the situations, in the hope that if it was ever challenged, that language would stand up based on trust law. Now the Tennessee Code is now giving you more strength behind that. Is that correct?
That's exactly right. One of the concerns, I guess, that the Tennessee legislature had was that there was a movement across the country in the various courts giving these remainder beneficiaries, we call them, let's say after the child dies, the child's children, giving the child's children rights to the assets or rights to the trust, even though they weren't really vested with an interest, or giving creditors rights through bankruptcy court proceedings, or giving ex-spouses rights through divorce proceedings. And so this kind of stepped in where we were just using trust language to try to protect these assets, and weren't quite sure how the Tennessee courts were going to interpret what we were putting in our trusts. Now the code has changed to say we're good to go.
This is one of the things that if you haven't had your trust documents reviewed, or if you've set them up, like I said, more than a year ago, if you haven't had them reviewed in the last year, this is something that's in particular importance to you. So understanding the way that these laws work. And by the way, you're welcome to give us a call, 737-plus, 737-7587, if you have any questions that you'd like to pose to Russ while he's here on the show. We're also going to make available to you a free consultation to have your estate planning documents reviewed. Now, here's the way this works. If you were to go to Russ's office, all right, he normally charges $300 to do a consultation. However, if you call my office to get this free analysis, you can meet with myself and with Russ at no charge. And all you need to do is call my office. This is a great way for you to protect your assets and the people you love, create a plan basically that you know then is going to work for your money and protect your money when you're gone. All right, from both outside attacks as well as protecting your family sometimes, as I said, with irresponsible beneficiaries from themselves. So to get this, all you need to do is call my office, 376-5325. If you're one of the first 5 callers to my office, 376-5325, you can schedule an appointment. We'll let you come in, speak with myself and Russ. We will review your estate planning documents and help you make sure that your documents are going to do what you intended them to do in the first place. And we've got a lot more to discuss about these new laws and what impact they're going to have on your estate plan. And we're going to get into it as soon as we come back. Join us here on the Retirement Report.